So, what would you do if you were forced to choose between your job and your professional ethics? That's really the heart of this high stakes legal showdown, pitting a single lawyer against one of the biggest mortgage lenders in America. It's a fascinating story about corporate innovation, a really controversial policy, and an attorney who says he was fired simply because he refused to break the law. All right, so to really get what's going on here, we're going to break it down into 5 key parts. First, we'll dig into the lawsuit that started it all. Then, we'll unpack the whole industry practice that UWM was trying to shake up. From there, we'll see exactly how a new company policy led to a standoff and ultimately a termination. And finally, we'll zoom out and ask the big question: where's the line between innovating and actually breaking the law? Okay, so this whole thing kicks off with a lawsuit, one that really blew the lid off a pretty serious internal conflict. And the lawyer for the plaintiff did not mince words. He accused the mortgage giant UWM of, quote, cutting corners and ignoring ethical and legal restrictions to enhance profits. I mean, the central claim here is pretty straightforward. The company was allegedly pushing its own lawyers to do something they knew was wrong. So let's meet the key players. On one side, you've got Rod Rosa. He was an in-house attorney for United Wholesale Mortgage. You probably know them as UWM. And on the other side, well, the company itself. Rosa's lawsuit, filed in California, claims he got fired for one simple reason. He wouldn't go along with a new company policy that he believed was flat out illegal. To really grasp why this is such a big deal, we need to talk about the industry UWM was trying to shake up. And this all comes down to something that's a part of almost every single home loan: title insurance. You know, for as long as anyone can remember, title insurance has just been part of the deal when you buy a house. It's basically a safety net. It protects you and your lender from any nasty surprises lurking in the property's history, stuff like old debts or some long-lost relative claiming they own the place. Yeah, it can be expensive, but that's the price for peace of mind, right?
But UWM, they came up with something different. They called it an attorney opinion letter, or AOL for short. The idea was, instead of that big, expensive insurance policy, one of their own lawyers would just check the public records and write up a letter saying, yep, looks good enough for a mortgage.
And right there, that's the big difference. Traditional insurance is all about selling you safety, that feeling of security. UWM's program, it was all about speed and saving cash. Their big promise was saving borrowers thousands of dollars on closing costs. And look, that's their whole play, being the innovator. But it begs the question, in that race to be cheaper and faster, did they end up cutting a major legal corner? So how does a supposedly innovative idea blow up into a legal nightmare? Well, it all boiled down to one single, really controversial change in company policy. See, for a while, the system was that UWM's attorneys would do all the legwork, they'd ghostwrite these letters, but then a local lawyer in whatever state the property was in would be the one to actually sign off on it. But then, in the fall of 2025, everything changed. UWM launched a new program, rebranded the letters, and then dropped the bombshell. Their own in-house lawyers were now required to sign letters for states where they weren't even licensed to practice law. As you can imagine, the legal team saw the red flags immediately and even sent management a 12-page document outlining all of their concerns. And management's response? It was basically an ultimatum, a really stark one. They said if any attorney refused to sign one of these out-of-state letters, they'd get a strike. Get 10 of those strikes, and, well, the company would just consider you resigned. So it wasn't a choice anymore. It was an order. And you know, the lawyers' worries weren't just them being overly cautious. The company's own policy admitted that doing this was explicitly, totally forbidden in these 10 states. For a bunch of other states, the law was kind of murky. It wasn't a clear yes or no. So this was the legal minefield their own company was telling them to march right into. And all of this leads right to the heart of the story: the personal standoff between one attorney, Brad Rosa, and his employer, UWM.
So why the sudden change? Well, the lawsuit alleges this wasn't just some long-term strategy. It was about an immediate problem. Apparently, there was a backlog of about 20 files that desperately needed signatures by a super tight deadline, November 28th. You can just imagine the pressure cooker environment. The company needed signatures, and they needed them now.
Now, Brad Rosa, he tried to be reasonable. He tried to find a compromise. He told UWM, look, I'm happy to sign letters for California and Massachusetts. Those are the 2 states where I actually have a license. He even offered to go back to ghostwriting for the other states. He made it crystal clear he wasn't trying to quit. He was just trying to do his job without, breaking the law and violating his professional ethic. But his attempt to find a middle ground, it was a no-go. A few days after that big deadline passed, he got a phone call and was fired. Just like that. A pretty abrupt end to his time at UWM. So you can see this case is about way more than just one guy losing his job. It really pulls back the curtain on a much bigger question about how companies are supposed to act, especially in fields that have a ton of rules. Now, to be fair, UWM sees this completely differently. From their point of view, this isn't about breaking the law at all. A spokesperson basically said this is a fight against the old, stuffy way of doing things. They see themselves as the innovators, the disruptors, taking on a powerful, expensive industry. And this lawsuit, they say it's just the kind of resistance you expect when you try to shake things up. Yeah, UWM's position is pretty clear. They're saying, hey, innovation often brings scrutiny. They argue they're really on the consumer side here, saving people money, and they are ready to fight for their program in court. And that really brings us back to the central question in all of this. I mean, we all want things to be cheaper, faster, better, right? But where do you draw the line? When does that drive to innovate and cut costs go too far and cross over into something unethical or even illegal? A court is going to have to make a decision in this specific case. But the question it poses, well, that's something that just about every industry trying to change the game has to grapple with.